Good morning, everyone. I would like to welcome everyone who is joining already our webinar, and would like to ask you maybe to wait for a couple of more minutes for others to join, because we have a lot of registration for this webinar, and we hope that this presentation of us will be, very interesting. From what we see, the interest is big, but let us wait also for others to join. So it's 2 minutes past 10. I think we can already start. I would like to welcome everyone to our live webinar on the new EU foreign investment screening regulation. I am Kai Scholz. I'm managing partner of Oracle Law Global, and together with my colleague, Mr. Ning Zhou, we will explore the updated regulation 2026/1386, which replaces the earlier regulation from 2019. This is a critical topic for everyone involved in cross-border investments in Europe. Please note that this webinar will be recorded for your convenience and will be shared later online also with you. Please feel free to ask questions during the webinar in the comment section, and feel free to use the Q&A section at the end of the webinar. So let me briefly introduce our law firm. Our law firm is Oracle Law Global. We are a problem-solving law firm based in Frankfurt with a presence across 19 European jurisdictions, as well as China, Africa, and Central Asia. Our practice covers banking and finance, corporate matters, M&A, energy, litigation, employment law, insurance, ESG matters, and also aviation. We advise on cross-border transactions, regulated industries, and clients with ownership and supply chains that span different multiple jurisdictions. Our firm serves clients in different areas, like, as I said, energy, infrastructure, private equity, technology, telecommunication, and also, as I just said, different other industries like transport and aviation. I am a German Rechtsanwalt. I am also duly qualified in Germany and in Azerbaijan. I am also a compliance officer, and my focus areas are including banking, finance, supervisory law, mergers and acquisitions, AML matters, compliance matters. And I would like to introduce you Mr. Ning Zhou. Maybe he can introduce himself better.
Yes, thank you, Kai. And I'm a Chinese lawyer registered in Frankfurt Bar Association and practice in both countries. I was working many years in energy sectors and have experience in M&A, cross-border M&A, international trade, and also other commercial practice area. Yes, I think most of the participants know me already. So I don't use too much time for myself. Thank you.
Great, thank you. And today's sessions is structured into 4 different parts, each taking approximately 15 minutes, followed by live questions and answer session. First, I will discuss the introduction and background of the EU foreign investment regulation, explaining why the EU screening is important and how we arrived at this regulation. Second, Ning will cover the key updates in the new regulation, highlighting what has changed compared to the previous regulation from 2019. Third, I will return to discuss practical implementation, including the main challenges and the notification and risk points that frequently catch companies off guard. And fourth, Ning will address the specific impact on Chinese clients and other clients and outline the key consideration for international investors from Asia. We will then spend 10 minutes on live questions from you. This structure ensures that we will cover both the regulatory framework and the practical realities of implementation. So now we are beginning with session 1, where I will provide the introduction and background to the FDI regulation. Many people confuse foreign investment screening with 3 other regulatory regimes. Let me clarify each distinction. First, foreign investment screening is different from merger control. Merger control, which runs through the European Commission, asks whether a deal harms competition. FDI regulation asks who the owner is. The 2 tests are completely different. A deal can be too small to require notification under EU merger control and still be blocked by a member state based on the FDI concerns. Second, FDI screening is not the same as sanctions or export controls. Sanctions and export controls restrict what you may sell to whom. FDI screening restricts who may own the company that makes the products or provides the services. Third, FDI screening differs from the foreign subsidies regulation, which policies distortive non-EU public funding. This so-called FSR runs on its own thresholds, its own timeline, and often applies to the same deal as FDI screening. The standard for FDI screening is security and public order, not competition, not consumer welfare. The decision maker is a government, ministry, or national security body, not a competition authority. FDI outcomes are discretionary, partly confidential, and unavoidably political. Usually, the result is not a simple yes or no, but rather a yes with conditions. This is critical because the standard is security rather than economics. The usual antitrust thinking, market shares, remedies, and past precedents is poor guide to what will happen. So let me walk you through the history of how this FDI screening went from a niche national power to a central EU policy. The journey began in 2017 when France, Germany, and Italy called for an EU-level response to strategic acquisitions of European technology companies. Before this, screening had been a scattered, informal national practice. In 2019, the regulation 2019/452 created the first EU framework. Crucially, this regulation did not create an EU veto power. Instead, it created transparency, a mechanism for member states to cooperate, share information, and express non-binding opinions. It became fully operational on 11 October 2020. During the COVID-19 pandemic times in 2020, the Commission urged member states to use screening to protect European assets that had become vulnerable due to collapsing company valuations. This accelerated the process. Screening regimes multiplied across member states and notification thresholds fell significantly. By 2023, as you can see on our screen, governments folded screening into a wider economic security agenda alongside export controls, outbound investment restrictions, and the foreign subsidies regulation. Enforcement volumes climbed sharply. In June 2026, just weeks ago, a new and more stringent regulation was adopted. It came into force on 16 July 2026, but it will not apply until 17 January 2028. The most important lesson from this history is clear. Every single step has widened the scope of the screening and lowered the thresholds. Nothing in this history has ever reversed or narrowed. Plan on the assumption that this trajectory will continue. And understanding timing is critical, as you can see also on this slide, because there is a crucial gap between when this regulation comes into force and when it actually applies. The regulation was adopted on 17 June 2026, published on 26 June, came into force on 16 and will apply on 17th January 2028. This gives us 18 months in what I call the runway. During this period, regulation from 2019 and the 27 national screening regimes remain the operative law. Your filing obligations did not change on 16 July. The trap lies in this gap. Deals being signed right now will close under today's rules governed by the 2019 regulation and national regimes. However, deals being structured now, holding company vehicles, fund structures, follow-on funding rounds, will live into the new regulatory landscape. So use this 18 months strategically to map your group structures and fix ownership chains. So let me show you the real data on what happens in FDI screening. Because there is a misleading headline in the statistics. In 2024, member states handled 3,136 requests for authorization and ex officio cases. 41% of those, 1,283 cases, went into formal screening procedure. The rest fell outside the scope of screening or were handled informally. Of the 477 cases formally screened and notified to the EU cooperation mechanism, the outcomes were, as you can see on the screen, 86% were cleared with no conditions, 8% were cleared with conditions, 4% were withdrawn before the decision was made, and only 1% were prohibited. The headline is that only 1% of screened deals are prohibited, which is why boards often assume FDI screening is a formality that will not affect their deal. But read the statistic the other way. Yes, only 1% are formally blocked. However, 9% carry conditions and 4% are withdrawn before decision. That means roughly 13% of formally screened deals are either reshaped or abandoned. 13 times as many deals are modified or abandoned as the formally prohibited. This is the real story. FDI screening does not often say no, but it frequently says yes, but only if you accept these conditions or causes the deal to be withdrawn. So the conditions can be expensive and operationally burdensome. Screening risk is not evenly distributed across all investors or all sectors. The data shows strong concentration patterns, looking at the ultimate origin of investors in notified cases during 2024, the United States accounted for 40% for all notified cases, the United Kingdom for 11%, China and Hong Kong combined for 9%, Japan for 4%, Canada for 3%, and others with smaller percentage. Notice that the largest source is an allied economy, the United States, which shows that screening is not targeted at any one country, but is applied as a filter to all foreign investors. Within sectors, manufacturing represents 25% of all notified cases, but it reaches 50% of cases that go into an in-depth review. Nothing else escalates to scrutiny like manufacturing does. Within the critical technology category, 37% of cases reaching in-depth review were defense-related, up from 26% the year before, an increase of 11 percentage points in just 1 year. Semiconductors accounted for 21% of critical technology cases. One member state concentration, just 4 member states, Spain, Austria, Italy, and France, were the source of 37% of all notifications. Where you file determines what scrutiny you face. Different member states apply the rules with varying intensity. So now I would like to hand over the next second to my colleague, Ning Zhou.
Thank you, Kai. Thank you. Good morning, everyone. Firstly, I welcome you again to participate our webinar. I will take over the floor and look at what actually changed. So if you already know the old 2019 rules, this part show you what is new and what you need to do differently. I will give you 7 key changes. But first, let's begin from a big picture. I will highlight 3 numbers. First is 27. That means every EU countries must now screen foreign investment. In the past, it was optional, but now every country should implement this new regulation. And 1, that is a new single shared list of sensitive sectors that need pre-approval. We will discuss this list in detail later on. And 2028, this is already mentioned by my colleague Kai, the new rule will fully apply from the 17th of January 2028. That sounds far away, but actually, if you are planning a deal right now, if you have experience of doing M&A business, it's quite a short period for your preparation. Yes, please move next. Thank you. Okay, so let's start from the change 1. That is fundamental. The screen is now required in every country. Under the old rules, a country could choose not to screen at all. I think only in this year, the last country, Cyprus, make their own foreign investment regulation. Before that, Cyprus has no such kind of screening system at all. But now in the future, every country is required to do that. And if an investor would like to pick up easiest place or easiest member state into Europe, the door is now closed. And Article 3 says every country must have a screening system and must tell the Commission about it before January of 2028. So in simple terms, that is no more screen-free or screening simple way into EU market. Then let's move to change 2. that is the shared sector list with pre-approval. Please, next slide. Okay. This is the shared list of sensitive sector. This is included in Article 4, number 15 of this new regulation. As I say that this clause is the most important of this new regulation. Please remember all the sectors. If your target works in any of that, you must get approval before you close in every country. So this list covers several critical sectors, such as dual-use goods, like civil, military-used items, chips, quantum AI, critical infrastructure, such as LNG terminals, ports, this is energy-related, and the power grid, and the battery storage station, that is most Chinese investors are focusing on, and key raw material such as rare earths, coal financial system, and election system. So one point to remember, in greenfield investment, building something new in Europe is now covered by the rules. So in the old regulation 2019, it was not, but now it is included already. Yes, let's go to the next slide. Okay, so this slide, I would like to introduce a new change. We start from a case law of Xella case. So in 2020, a Hungary company called Xella triggered to buy a local target in Hungary. On paper, the buyer was a European, but its real owner sat outside the EU through Germany, Luxembourg, and Bermuda. So you can see the shareholding chart on the right side of the slide. And the Hungary authority blocked the deal because they said that it's a foreign investment because some entity in the ownership chain sit outside of EU. And 23, the European Court said the old rules only caught non-EU buyers. So this EU company fell outside of that. This gap is exactly what the new rules now fixed. Please move next. So what is changed regarding this kind of case? That is closing the Xella gap. So here is the change itself. The old rules covers foreign direct investment, and the new rules use a wider term, foreign investment. That means that include direct investment and indirect investment. This now catch deals made through a foreign investors' EU subsidiaries, the same risk that used to slap through. The name comes from that Xella case, but there's one limit. If you only take a small passive stake with no control, you still stay outside of the EU. And we go to change 4. That is a greenfield investment I have mentioned. A greenfield new facilities, that is building new facilities in EU, is now in scope and can be reviewed. But it only can be reviewed. It doesn't need a pre-approval. So internal group restructuring are usually out if the real owner does not change. But this is one exception. If a new non-EU company is added above the target in the ownership, the deal is caught again. Let's see 3 examples to explain this rule more details. Please move next slide. Okay, so this is at least 3 scenario. On the first scenario, a non-EU group just move their company, their EU target, under German subsidiary to his French subsidiary that within one non-EU beneficial owner. So that is a pure restructure of the group within EU. So this kind of a deal is set outside of the scope. However, if we go to scenario 2, a new non-EU shareholder appears after the target was moved from German subsidiaries to French subsidiaries, because French subsidiaries had a new non-EU beneficial owner. So that case will subject to the new regulation and stay within the scope. Scenario 3, it's similarly, French subsidiary has a shareholder that is a EU beneficial owner. So in that case, this is also a EU restructuring and stay outside of the scope of this regulation. Okay, so let's go to change number 5. This is a two-phase review. This is all about the process. So all the screen or review now has 2 phases in every country. So phase 1 is the first look. It must reply and give a response to the investors or applicant within 45 calendar days of complete filing. To remember here, that is a complete filing. You cannot just file an application and wait 45 days. You must have a very good prepared filing to the authority, then start the phase of 45 days. And phase 2 is a deeper review. Only there's a concern when the authorities think there's an actual concern regarding the security and or public order. So 2 points matter for you deals. First, stand deal. If the approval is needed, you cannot close until you get authorization on the deal. Secondly, even a deal you never filed, that can be reviewed later. That is like reverse review after 15 months to 5 years. So this period will decide it. So this the regulation only give a scope of the period, but exactly time of the period will decide it by member countries themselves. So closing quietly does not make the risk go away. Then let's move to change 6. That is not about the commercial entities, but its obligation or scheme between EU countries. Now EU countries work much together with new tools. Some deals must be shared with all countries and the EU Commission. Others can then comment. They can also comment, and the Commission can also give an opinion, even on deals that never filed, up to 15 months after closing. Behind this is a new EU machinery, a shared database from 2027. And also they will set up an online filing portal for the whole European Union. So this, I think, it is also a good news for foreign investors that they have like a single way to file for approval, not differently in 27 countries. Then next, change number 7, the last one. When we file for application, we should know what authorities now wait and they are focused on, or what they are thinking about. And the rules now list what authority look at. On one side, the fact of the deal. So they will look at critical technology, infrastructure, sensitive data, public health, food supply, and something similar like that. Critical infrastructure for the whole whole EU. And on another side, they will also look at the investors itself. Is it state-controlled? It is under sanctions. It is subject to a foreign law that force it to share information. Its ownership unclear. So please keep this second list in mind. It leads directly into my next session. And the last page is a comparison of the old one and the new one. It's just a summary and a glance. It's a repeat of my previous slides. This is the end of my session 2. I will give the floor to my colleague Kai regarding implementation.
Thank you very much, Nick. Thank you for this great overview. And now we are moving to session 3, which I will present. The session covers practical implementation, the challenges you will face, and the notification and risk points where deals most often go wrong. This is kind of 10 minutes, 15-minute segment. I will outline 6 common blind spots that trip up even experienced practitioners. This is the first blind spot on your screen. Who counts as a foreign investor? Ning touched already on this topic. Many companies assume that if they are acquiring through a European holding company, the FDI regulation does not apply. This assumption is not right. The regulation includes an explicit look-through. Shareholding percentages do not dilute down the chain. It is a critical rule. An EU incorporated company that is itself controlled by a non-EU person is treated as a foreign investor for FDI purposes. An EU flag on your acquisition vehicle is not a shield against screening. The regulation defines a foreign investor subsidiary in the Union precisely to close this loophole. So let me give you a practical example. German practice applies what is called the separate testing rule. There is no multiplying of shareholdings level by level. If you hold 10% of a holding company that itself holds 10% of the target company, you are treated as a 10% indirect acquirer of the target. Each link in the chain is tested separately. This means a very small economic interest, potentially around 1%, can trigger a filing obligation. Another trap, which I can say involves internal reorganizations. Reorganizations with an unchanged beneficial owner are only conditionally exempt. If a pure paper restructuring introduces a non-EU entity, a new non-EU entity into the ownership chain, it can trigger a notification requirement, even though the ultimate economic owner has not changed. Funds present another issue. Fund investors may not remain anonymous. Spain treats the management company as the beneficial owner. France requires the identity of the managers and of whoever controls them. Dutch guidance, for example, warns that funds managers may not stay incognito. Funds of fund structures must be mapped carefully. One more critical point, an opaque ownership structure is now an aggravating factor in the merits assessment under the new regulation. Obscurity itself counts again against you with regulators. The second blind spot is what counts as an acquisition. Many companies assume that holding a minority stake with no board control means there is nothing to notify. This is dangerous. The regulation sets no single percentage threshold across all member states. Instead, each country maintains its own thresholds. So let me list some of them as examples. You can see on your screen. Italy's defense regime has 7 different thresholds at 3, 5, 10, 15, 20, and higher percentages for non-EU investors. Germany screens 10, 20, and 25% thresholds for general FDI, but defense acquisitions are subject to a 10% threshold for all foreign investors, including EU and EFTA ones. France applies a 25% general threshold, but only 10% for listed companies. Spain uses 10% of where there is decisive influence. The Netherlands screens at 10, 20, and 25%, plus any case involving significant influence. Austria screens at 10, 25, and 50% thresholds, and control is not always required. Here's a trap: creeping acquisitions. Clearance is not a season ticket valid forever. If you obtain a clear 12% stake in a German target, for example, that clearance applies only to that transaction. When you acquire additional shares reaching 20%, that is a fresh, separately notifiable transaction. Moving to 25% is another new transaction. Denmark, for example, has 6 different thresholds. The follow-on funding round is the classic missed filing. Another critical concept is control without shares. German practice reviews what is called an atypical acquisition of control. This means that veto rights, a guaranteed board seat, or enhanced information rights can trigger screening, even if no equity changed hands at all. Danish rules reach shareholder agreements, loan agreements, and finance agreements. A side letter between parties can be the trigger for a filing obligation. Finally, reject the assumption that being European means you are not screened. Germany's defense review applies a 10% threshold to every foreign investor, expressly including EU and EFTA investors. Spain's first public veto in 2024 was a Hungarian acquirer. Being European is not a safe harbor. The practical rules for this case from my side do not diarize deals, diarize thresholds. The filing people miss most often is on a company they have already cleared once. The third blind spot is whether your target company is really in scope at all. Many companies assume that if they are not in the defense or semiconductors business, they do not need to file. That assumption will cost you. The regulation establishes a mandatory minimum scope that every member state must screen, and member states are permitted to go further. The mandatory scope includes defense and dual-use items, semiconductors, quantum computing, and artificial intelligence, strategic raw materials, energy, transport, and digital infrastructure where they are critical, financial entities and market infrastructure, and electoral systems. The test of whether something is in scope runs entity by entity, not on a consolidated group basis. Your registered activity code is, in this case, irrelevant. The test is what an entity actually does and who depends on it. Several regimes deliberately avoid code-based tests. This is because company registration are often stale. One small subsidiary with one sensitive contract can pull an entire multi-country group into the scope. Sensitive activities often generate very little revenue, so they hide. Dual-use items catch distributors. The regulations reaches any company that commercializes a listed item, not just manufacturers. And dual-use classification is self-assessed by companies. Research alone is enough. A company conducting research in semiconductors, quantum computing, or AI even pre-revenue with no product would be also in scope. Raw material screening includes stockpiling. Simply holding strategic materials can trigger scope, and the lists themselves can be amended by a delegated act without warning. Here's the honest summary. Scope diligence has a shelf life. Answer the question about whether a target is in scope at the term sheet stage in writing. When re-ask again, if the deal takes more than a few months, the scope can change. The fourth blind spot is how long a screening process actually takes in practice. Regulation text says 45 days for a phase 1 review. Many companies add buffer time and assume 90 days total. This is dangerously optimistic, I would say. Let me explain 5 reasons why 45 calendar days is not 45 days in reality. First, there is what I call the same day filing paradox. A recital in the regulation urges applications to file in all relevant member states on the same day. But the event that starts the clock differs from the member state. In Poland, you can file before completion. In Austria, you must file immediately after the transaction is concluded. In Hungary and Italy, you have a 10-day window after conclusion. Aligning filings on one date means aligning the entire deal architecture around the strictest regime. Second, the definition of complete filing is not harmonized in the EU. Member states decide separately what counts as complete. Questions from authorities can continue even after they confirm your filing is complete. Third, phase 2 in-depth review is not harmonized, so no EU duration is fixed, and not every member even requires a phase 2. Fourth, an authority can open an in-depth review simply because it's phase 1. Time limit ran out. This is called spending the clock. Fifth, remedy talks stop the clock in Germany. The review is suspended for the whole negotiation with no backstop date. FDI is the long pole in your deal timeline, not merger control. EU merger and foreign subsidies regulations phase 1 reviews both run around 5 weeks with hard backstops. FDI has no comparable backstops. On early commission data, about half of deals notified under the foreign subsidies regulation also carried an FDI filing. So the fifth blind spot is what happens if you get it wrong. Many companies assume the worst case is a fine paid after closing. They think, let us close and sort it out afterwards. This is catastrophically wrong. This is not a fine risk. This is a title risk. In Germany, a notifiable acquisition closed without approval is provisionally ineffective, if no legal effect at all. Voting rights are unusable and you cannot access company information. In France and Spain, an unauthorized acquisition can be void. In Italy, the corporate resolutions themselves fall away. Investments that were not subject to prior authorization can be called in for review between 15 months and 5 years after completion. A missed mandatory filing can be called in for at least 24 months with no upper ceiling stated. A negative scope conclusion never fully expires. Penalties on paper are severe. In Italy, the penalty can be up to twice the transaction volume with a minimum of 1% of target company turnover. So only one large penalty is fully documented in the EU, 74 million euros imposed on Telecom Italia for failing to notify Vivendi's acquisition of control. This case was litigated from 2018 and confirmed by the administrative court in 2025. German federal prosecutors are reported to have opened a first criminal circumvention case in June 2026, 4 years after the events. So the honest headline is this: deals do not die from the fines, they die from the delay and from conditions. And remember, no filing required is an opinion, while a clearance is a decision. So the sixth and final blind spot concerns conditions and what your contract can absorb. Some negotiators think we will take the FDI risk on the buyer and cap it with a break fee. It is a standard closing protection. But here's the problem: the FDI condition cannot be waived by agreement between the parties. In a mandatory suspensory regime, closing without clearance is void or ineffective. Unlike an antitrust condition, this is not a kind of commercial choice the parties can agree to live with. What does cleared with conditions actually mean in practice? It means conditions are typically behavioral and governance related. Examples include caps on investor-nominated directors, restrictions preventing the investor from chairing the board or its committees, a requirement to appoint a director from the host country who is security cleared, restriction on integrated IT systems, prohibition on treasury centralization or cash pooling, placement of source code and know-how in escrow with a local third party. So the problem is that national security remedies are behavioral, not financial. A carve-out capped at the percentage of revenue does not catch an obligation to appoint a local board director or to unplug your IT integration. You must define the maximum burden financially, operationally, and structurally. Conditions are litigible and political. Italian conditions on the UniCredit acquisition of Banco BPM were partly annulled by courts. The bid was withdrawn and the Commission opened infringement proceedings against Italy. Conditions are contestable, but contesting them takes longer than any deal timetable. Divergence is extreme. France attaches conditions to more than half of its authorizations. Germany attached conditions to a very low single-digit share. The market is moving. FDI conditions now appear in around 1/3 of deals above $500 million. And reverse break fees are increasingly priced priced of foreign investment unpredictability rather than antitrust risk. So now I would like to hand over this fourth and last session to my colleague Ning.
Thank you, Kai. For my last part, I want to bring the topic to the clients I work with mostly, the Chinese investors. The new rules affect them more than almost anyone else. Let me explain why and how to prepare for them. Please move to next slide. As I thought, there's 4 reasons this regulation impact Chinese investors. Although, as I say, this is regulation definitely not designed against China, not designed against the Chinese. But however, our investors, as part of foreign investors, will be influenced definitely. There's 4 reasons I can discuss. First is the sector overlap. The Chinese deals often target exactly the sensitive sectors, such as chips, AI, batteries, raw materials, and infrastructure, in particular energy infrastructure. And secondly, state links. State-owned or state-funded investors will trigger a EU-wide notice automatically. That means if a state-owned company acquires target in one EU member state, the EU member state is obliged to notice other countries and also EU Commission. And the third, the Xella gap is closed, as I discussed in last session. Buying through a EU a company no longer avoid a screen. And the fourth is transparent. If the ownership structure is untransparent, it's too complex, that will lead to extra attention. So in a word, if where the interest is highest, the review is now hardest as well. Please, next slide. Okay, there are some triggers that will lead to watch or lead to focus of the authority. One is a state-controlled and the policy and military concern, and also intelligence share laws, and fourth, unclear or, as I mentioned, unclear or non-transparent ownership, and possible sanctions and anti-money laundering controls. If a country, they have a weak money laundering control, that will also be checked more than others. Okay, please, next slide. Okay, let's see something positive, obviously positive. What stay outside of the scope? So firstly, currently in EU level, they focus on the sensitive list that is in Article 4, number 15. All other sectors, in addition to that, will outside of that list is not mandatorily by EU for pre-approval. Maybe the member countries, they can make a stricter regulation by themselves, but so far on EU level, that is all of the sensitive sectors are listed in this regulation. And also some small passive stake portfolio investment with no control of the target will stay outside of the scope. And the inter-company or inter-group reorganization with no new foreign owners are not caught by this regulation. And also, we have mentioned greenfield, that a greenfield investment was included, but subject to no pre-approval before closing. Maybe they can look back, but they don't need to file application before the closing. Okay, next, let's see upside. We talked a lot of items regarding the restrictions, screen, but I have to see that EU or European is still open. Always, I can see European Union is at least one of the most open market in the world still. Even there's a screen and more regulation regarding foreign investors, or foreign buyers, foreign suppliers, but screen is not a ban. The most filed deal are approved, as you can see the number from my colleague Kai. 86% of deals are approved finally. So that we see a lot of negative information that is prohibited in public media. However, if you work in this area, in this industry, you will know most of the deals are approved, even without condition. But we can see more and more condition will impose in the future. But still, this is not a reason to quit from the market. Yes, thank you. Also, a good news, there is the theory of the regulation has a priority that they prefer to approve deal with mitigating measures rather than rejecting them. So let me show you the kind of conditions that can save a deal. the law says the measure must be enough to remove the security concern. So they can include, for example, keeping the business running, buying key parts from a trusted supplier, adding cyber security, keeping certain data inside of the EU. I think many of my clients already done so. They are operating and maintain a data server in Europe. Also change the governance structure and limiting the investors' voting right, setting rules on access to sensitive technology, something like that. So in a word, we have many ways to cancel the concern of the authority and get the deal approved. Please go to next slide. This is a path to clearance. I think Kai already talked a lot regarding that. I don't repeat. Just one point here is the 45 calendar days is for the first phase of initial review. For the second phase, that is in deep review by member state, they have no unified timeline in regulation. That means the member state will decide by themselves how many days they need or how many months they need for the deep review of deals. Okay. And also key considerations for Chinese investors. I think Kai already covered this part. I don't repeat. Please go next. Okay, this is the most important part, how we can help. So finally, we can test, we can do many things for our client to a successful deal. We can test the target against the sensitive list and flag any filing triggers before you sign. We build ownership and deal structure that clears cleanly. We prepare submissions and that make the submission more easier for authority to accept. If necessary, we can provide solution or remedies for possible questions from the authority. And also our China desk bridge both sides, the regulators, the language, and the commercial expectations. In short, we can help you to get to yes of the deal. Yeah. So this is the final part of my session. And yeah, Kai, please.
Thank you very much, Nick, for this great overview. We have now reached our live question and answer session. We have some 5 minutes for it. Please use your Q&A or chat panel to submit your questions, or you can, of course, reach out to us after the session. This session will be recorded, as I said, and will be, of course, also published online. But you can always, of course, reach out to us with your questions. And this presentation will be also shared with you, where you can see at the last page our contact details, and you are always, of course, free to contact us in case of any questions. So if there are any questions, please feel free to ask now.
Or if some participants, if you comfortable with question in Chinese, please let me know. Yeah, just ask and I can translate.
Okay, so if there are no questions at this stage, thank you very much, Rachel. Thank you very much for your kind words. I really appreciate your participation, and we are, as I said, always open for any kind of discussions you want to have with us in these topics. Please feel free to reach out to us. Ning, as you know, he is, of course, head of our China desk, will help you with in Chinese language with all your questions. But if you have any kind of other questions from other parts of the world, you can reach out to any one of us. Thank you very much. I wish you a nice day, and a successful participation in this transition period for FDIs. Thank you very much. Bye-bye.
Thank you. Thank you very much. Bye-bye.